Artificial Intelligence, Creative Works, and Law panel. I'm Wynton Yates. I go by Lawyer Wynton on social media. I'm a New Orleans-based entertainment attorney, but I work with arts and entertainment professionals all across the country. So I live in New Orleans, but I work with everybody across the country. Today, we're going to be talking about and discussing this recent boom of creative works generated by artificial intelligence. What you as arts and entertainment professionals need to know about its potential impacts on intellectual property law, and what you can start doing now to protect yourself and your work, because that's going to be so vitally important going forward as arts and entertainment professionals, that we have a real good understanding of everything that's happening with artificial intelligence and generating creative works, because it's not going anywhere. This is one of those things that is here to stay. I know we hear that a lot in our industries with trends that come, and we see trends come, we see trends go. But I can definitely tell you this is one that is here to stay. Artificial intelligence is not going anywhere. So we're going to talk about it today. Again, I am an entertainment attorney, intellectual property attorney. So I work with arts and entertainment professionals, not only with their specific skill sets across the board, whether it's writers, novelists, comic book artists, graphic designers, visual artists, who else? I have influencer clients, YouTubers, TikTok, all across the board. You name it, in industry, filmmakers, I work with them and work for them and advocate for them. So that is what I'm here for. I love talking about this stuff. It's really, honestly, my passion, and what I used to do before I became an attorney. I was a creator. I was in the arts and entertainment world as a professional in that capacity before becoming an attorney. But now I love advocating for professionals. I love talking about this stuff. It's my passion, like I said. But what I love even more is engaging with you guys in the chat. Because I am by myself, this is all Q&A for me. I'm gonna talk. I'm a talking head. I can talk about this stuff all day long. Please feel free to drop your questions in the chat section of the Q&A section of the chat at any time. I highly encourage questions. Excuse me. But I'll give you a quick heads up. If you ask me about a very hyper-specific legal situation that's going on with you or a friend of yours or something like that, the answer more than likely is going to be, it depends, just because I don't know all of the ins and outs and details and nitty-gritty of your specific situation. And there could be things that change legally what's going on with your specific situation. I also tread lightly with offering specific legal advice in this kind of format, just to keep from accidentally creating some kind of attorney-client privilege that gets a little spicy. So I highly encourage questions, but nothing specific about like something that's going on specifically with you. All right, so let's start off with a little tiny bit of history around artificial intelligence and creative works. And I'm sure a lot of people don't realize that artificial intelligence and creative works have been around since the 1960s. It is only recently that it has evolved into what we see today, where it is just cranking out and generating creative works all across the board. We're talking about film, television, poems, books, visual arts, you name it. Artificial intelligence is now cranking it out at a high rate. So back in the 1960s at the University of California in San Diego, a man by the name of Harold Cohen designed an artificial intelligence art system called Aaron, AARON. And he actually designed it to program it to use it with the goal of coding the act of drawing. So he would put in these codes. Aaron would do these primitive black and white drawings, and then Cohen would go back later and actually finish the drawing by painting them. that is what we knew of artificial intelligence generating some kind of creative work back then. And now, as we see it today, it is I mean, you see this art piece behind me, that's not artificially generated, but it is cranking out works that look eerily similar to what we see created by human authors, right? So how? Just a little bit of the how. We're not going to get into the technical nitty gritty of how it is actually generating these works. But the important thing to know about artificial intelligence and creative works is that these AI platforms across the board, whether you're talking about Midjourney, Stability AI, DeviantArt, any of them, right? The programmers and the developers that are creating these AI platforms train them by scraping the internet. You're going to hear a lot of them refer to it as scraping. To me, as an attorney, this is just a very spicy way of saying they're going out, they're looking at existing art, creative works that exist out on the internet, right? That it can go out, look at, learn from, and then pull into its system, right? So to me, scraping is just a new word to say something that we all know what it is. It's going out, it's looking at existing works, it's learning from those existing works, and then it's retaining some sort of information from it. Once an AI platform is trained, users can then go in to that platform and insert certain prompts telling it what they want to generate. So you can go in and tell it just about anything, give it all kinds of rules and guidelines and boundaries, and you can tell it exactly what you want to generate. You can tell what you want to see in the creative work, what style you want to see in the work, what color. Whatever rules you put on it, the AI is going to generate it, right? You put those in, you hit enter, and then a few seconds later, it pops out this creative work. And as we go through this talk, I want to make sure that everybody understands you will always hear me refer to creative works that are generated by artificial intelligence as generated. You will never hear me say that it is created by a human. So why is this conversation so important, right? And with ownership, all of us as arts and entertainment professionals understand the importance of ownership when it comes to creative works, right? All of us are in this industry, and we know if we're trying to sell a piece of work, if we're trying to license out a piece of work, if we're trying to license a piece of work, you have to first understand ownership, right? And with artificial intelligence, that is the first question. Who owns the piece of work that is generated by artificial intelligence? Real quick, somebody dropped a question in the chat. Recently, SAG-AFTRA got involved with Apple using published audiobooks to train its own AI, basically using their own word to replace the human narrators. Any groups working on legislation to protect the IP and narrators, voice actors' rights. Voice acting was my dream job when I was younger. So I love voice actors. But right now, overall, there is a lot going on within with IP and the protection of creative professionals, whether it be voice actors, visual artists, anybody in this industry, right? And right now, the biggest issue that we're having is the lack of legislation and the lack of litigation. And litigation, as an attorney, is hugely important in evolving spaces like this because it helps us go into courts, make our arguments, and establish rules moving forward to help protect creators. Right now, these things are unlitigated, which is just a massive issue because there are no rules set within the courts. Now, we do have rules set by the US Copyright Office. The US Copyright Office has come out several times in the last couple of years that we recently saw where a graphic novel by the name of Zarya of the Dawn was awarded or given copyright protection last year by the US Copyright Office. And it was a huge deal because this was the first instance of a creative work generated by artificial intelligence to be awarded. However, earlier this week, February 2023, lost you for a few minutes. Hopefully we didn't lose too much. Okay, so earlier this week, Zarya of the Dawn, the graphic novel that was partially generated using Midjourney, the US Copyright Office finished their reconsideration of that protection that was awarded to Zarya of the Dawn, right? Earlier this week, they partially canceled its copyright protection because of a lack of human authorship. And that goes back to what we were just talking about a little bit ago. And thank you for that question, because it fit perfectly into what we're talking about, Lynn, is ownership. So when we're looking at questions like what Lynn asked about Apple publishing all in its audiobooks and all other spaces within arts and entertainment, is we got to go back to ownership. Who owns it, right? And if we know that the Copyright Office has said it is ineligible for copyright protection, then we have to go and look at the basic rules of the Copyright Act of 1976. I don't want to get all law school on you guys, but we're just going to touch on some basics, some super, super basics that I think are super important for all industry professionals to know and understand, right? And the Copyright Act of 1976 forms the basis of copyright law in the United States today. It gives us a few basic understandings, two. We're going to talk about two of the basic understandings that are going to help us move forward in this conversation, just knowing, okay, let's go back to the basic rule. And remember, when it comes to the law, as hard as it may be, and I know it's hard, as hard as it may be, let's not infer any of our own feelings or thoughts, or we can't really interject our own meanings into the law. We have to look at the black and white letters of the law and what it says, right? And the Copyright Act of 1976 tells us that copyright protection extends to all, exactly, the law doesn't have feelings. The Copyright Law Act of 1976 tells us that copyright protection extends to all, quote, original works of authorship. It further tells us that the ownership of that protection is generally vested in the original author of the creative work. So if we just take that rule by itself and look at that basic rule, and this is not taking into account joint works, where you're going to have multiple owners of a creative work, or work for hire, where you're going to have someone who hires someone to author an original work, but the author of that creative work retains zero ownership over that work. It's the person who hired them to do so. If we're just looking at the basic rule of the author of the creative work owns the copyright. We go back to look at artificial intelligence. Is it legally okay to brainstorm with an AI system? Yeah, yes, it's legally okay, but you have to take into consideration what we're talking about in this conversation today, right? So just going back to what I was saying, in that if we're looking at ownership and we're looking at the basic understanding of ownership, right? And maybe we should take one step back and talk about, real quick, let's talk about how a lot of arts and entertainment professionals come to me with issues around copyright infringement, and somebody stole my work. I'm not sure what to do. I didn't register it, blah, blah, yada, 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 and so forth. Yada, yada, it's not a negative. I'm a huge Seinfeld fan. If you know yada, yada, the yada, yada. So, In the Constitution, copyright is in the Constitution, Article 1, Section 8, Clause 8. If we go down that rabbit hole, we find out that copyright protection is automatic and immediate. You just got to check a couple of boxes. You don't even have to register. There are a lot of advantages and reasons why you should register your creative works, and we'll go over that in a little bit. But copyright protection is automatic, and these are the boxes you got to check. It's got to be original. It's got to be an original work of. It's got to be an original work of authorship, and it's got to be fixed in a tangible means of expression. Right. So it's got to be an original work, and you got to fix it in a way that it can be perceived in some kind of way. You can see it, you can hear it, you can feel it, you can. As long as you can perceive that work, and it is original, it is immediately imbued with the protection of copyright. It is weak, but it does have copyright protection. Now, you want to register it for several other reasons, which we'll come back to in a little bit, but this is where we get back to the conversation of ownership around artificial intelligence. Who owns it? If it is generated by artificial intelligence that has been trained with all of these hundreds of millions of works, existing works, who owns it, right? Is it the person that created the algorithm that developed the platform? Is it the person, the user that is inputting the prompts to generate these creative works? Or is it the hundreds of millions, hundreds of thousands, tens of thousands of artists whose work was scraped to generate this work? Who owns it is the question. And this is why the Copyright Office is so slow, in a very good way, slow to award copyright protection to artificially intelligent generated creative works, because we don't know who owns it. And ownership is so important, because in our lines of work, ownership is key. Because when you're going out and you're doing a sync deal, or you're doing a licensing deal, or you're trying to sell or transfer that ownership, you got to be able to clear that chain of title to be able to do those deals and make your livelihood with your work, right? So if we don't know who owns it, then what do we do? It also opens up the question of, if it is ineligible, like the Copyright Office says, ineligible for copyright protection, does it then fall into the public domain? My thought is, if something is generally ineligible for copyright protection, then it then exists in the public domain. We know that if something exists within the public domain, you don't need permission for somebody to come in and use it commercially, right? So if something is being generated that is based on, or could be argued to be, a derivative of another person's work, have they now dumped someone's work indirectly into the public domain and devalued the original work? Which is one of the big questions that a court is going to look at in a copyright infringement suit, right? So asking all of these questions and putting all of these questions out, it really starts to show people outside of arts and entertainment the value of the U.S. Copyright Office taking a step back, moving slow, really looking at this. The filing class action lawsuits, and I believe there's another class action lawsuit that was filed against a few of the artificial intelligence platforms. But it shows the value in that, because we need to start establishing some rules around what is going on with artificial intelligence and generating creative works, right? The other thing for me is the ethical implications behind all of this, is that we understand how important arts and entertainment is to society and human beings as a whole, right? In the US Constitution, the writers of the Constitution, while they missed a lot of other things in the Constitution. One thing they didn't miss was the understanding that innovation, scientific, and creative forward movement is important to society. And that is why copyright, trademark, patent, intellectual property law exists, because it wants to continue to push scientific and creative innovation forward. Now, if we have instances like we have right now with artificially intelligence generating creative works, just unencumbered, just out there like the Wild West, we run into a situation that I'm seeing personally with my clients and potential clients of artists really pulling back on the reins and saying, hey, I'm not putting my work out into the world, risking it being scraped up by one of these artificial intelligence platforms and spit out possibly into the public domain where I cannot eat, essentially, right? I can't use my work for commercial gains in the way that I want to be able to use and protect my work, right? So let me pause right there and make sure, let me check the chat real quick and make sure nobody has any questions. Am I moving too fast? If anybody has any additional questions. Lynn, another good question. Could scraping be considered fair use as an argument by those who do it? What exactly is scraping? I'm an author, so I'm not thinking of my work being scraped, actually words. My audiobooks were part of the Apple AI scraping, by the way. I'm sorry to hear that your work was part of that AI scraping. We're in the middle of a bit of, and I don't want to sound apocalyptic, but we're kind of in the middle of a creative nightmare for a lot of creative professionals, because it is a scary environment to know that your work could be scraped. And to say exactly what scraping is hard because, like I said, this is all unlitigated. So the only things that we as legal professionals in this field can go off of is the information we're seeing that is being put out by the platforms, and they're being very, very specific on how they approach the conversation of scraping and what they're talking about, what scraping is, right? And they're trying to downplay what scraping is. What they're trying to put out there is that scraping is just, we're going out, we're just kind of doing they almost make it seem like if you're reading a book and you just kind of glance through the pages real quick and you just kind of, you get a little vibe of what's going on, right? That's what they're trying to make scraping feel like. It's not a big deal, right? But as a legal professional in this world, and you guys who are on the front lines of the creative and arts and entertainment profession and industries, understand that scraping is not just a little, we're just going out and taking a glance at things, right? If you're just going out and taking a glance at things, you wouldn't be able to generate these high gloss, highly finished products, right? So unfortunately, to say exactly what scraping is, I'm not sure, but I'm glad you asked about fair use, because on my social media, I talk about fair use all the time, because there's a huge misunderstanding of what fair use is. And fair use is a legal theory, and it's a defense. You cannot go into something saying, what I am doing is fair use. The only entity that can decide what fair use is a court, because fair use is a defense. You can only claim fair use if you have been accused of copyright infringement or trademark. Copyright, we'll talk about it in the context of copyright infringement. So if you all create something, I go in and I use it, you hit me with a cease and desist or a lawsuit saying that I'm infringing on your copyright, My defense to that, my answer to that is that, hey, this is fair use. But I cannot decide what fair use is. You can't decide what fair use is. The only entity that can decide what fair use is a court. So you go to a court, and there's going to be a list of elements that a court looks at to decide what is fair use. And the four factors are, the first factor is going to be the purpose and character of the use. Why are you using it? The second factor they're going to look at is the nature of the copyrighted work. The third is going to be the amount and the sustainability of the portion that was taken. So here's where I get a huge argument from people. Is like, I only used 10 seconds or a small bit of this creative work in what I was doing. It's fair use because the law says I can use a little bit. Actually, there is no law that states that there is a certain percentage that you can use that qualifies as fair use. So you can use 1%, 0.1%, but if a court looks at it and decides that that small portion that you use was a very significant aspect of the overall piece, the overall creative work, it falls outside of fair use. Now, the important thing to understand about fair use is that fair use only applies to certain things. It only applies to criticism, commentary, scholarship, education, or research. There's a very narrow avenue with which fair use applies. The fourth and biggest factor that a court's going to look at is the economic impact on the original work, which is, to me, I believe everything else within fair use kills the idea that scraping or AI training on these existing works is fair use. But this one, to me, is the biggest killer because these are mega companies that are financially, economically benefiting off of the backs of smaller creators, bigger creators, all creators, financially, and devaluing the original work. So if I create an AI that goes out and scrapes and reproduces your work in a different way, dumps it into the public domain where it can be used freely for commercial value for anybody and everybody who wants to use it, that to me immediately devalues your original work. Because why would I come pay you a licensing fee to use your original work if I can just recreate it using artificial intelligence? That to me is going to be a huge argument as all of this starts to get litigated. Drab asked, has scraping been legally defined yet in the space of policing policy, meaning using scraped images to build police databases with data? Yeah, so scraping, again, has not been legally defined yet because it's unlitigated. And these artificial intelligence platforms are very, very hush-hush on the nitty-gritty ins and outs of how scraping actually works. So if you go out and say what you think scraping is, you're immediately going to get a response from them saying, no, that's not scraping. But they're never going to actually tell you what scraping is. Somebody else said, Lord, that YouTube fair use footage is wild to think about. YouTube, yeah. This has been such a validating discussion, says Jesse. It's reassuring to hear your legal perspective on it. I appreciate you saying that, Jesse, because this to me is the most important conversation that we as arts and entertainment professionals need to be having right now. Because this, again, not to sound apocalyptic, could have massive impacts on the arts and entertainment professions going forward in the way that you all are able to function and make a living and move forward as living, breathing professionals in these worlds. Does that mean that Creative Commons license has not been helpful if the court if the court is deciding fair use? So scope of what can be used as fair use. So again, commentary. So when you think commentary criticism, think about the news. Think about YouTubers who get on and give their opinion about the most recent, but think about the most recent, when you're thinking about fair use, criticism, commentary, you're thinking about folks that are on YouTube giving their most recent, their opinion of the most recent movie, their most recent opinion of video games, and they have like video of the video game or video of the movie running, and how do they get past copyright infringement? That's because they're working, that is a good example of fair use, where it's commentary, it's criticism. You are adding something to that, you're adding some significant transformative this to that that piece of creative work. That is not just straight up copying, right? Exactly like a news report. And I used to be a news reporter before becoming an attorney, a news reporter for several years. So I had to do this a lot. As a visual artist who can definitely not afford a lawyer, I'm gonna stop right there. I'm gonna read the rest of that question, but I get that so much. Most artists who come to me say, I cannot afford, like they start the conversation with, I cannot afford an attorney. Yes, you can. I'm going to tell all of you right now. There's 22 of you in here right now. I'm talking directly to each and every. If you run into a legal issue with your work, copyright infringement, trademark infringement, anything, licensing, you need somebody to advocate on your behalf in a deal, you can afford an attorney. If you go to an attorney that is gatekeeping or makes it impossible for you to feel like you deserve that advocacy, go to someone else, because you absolutely can afford an attorney. Me specifically, my friends and colleagues, I had a colleague that was supposed to join me today and just had something come up with their family. We structure the way that we work with our clients in a way that makes it affordable to them. I promise you. Most people are going to think, oh, if I'm working with an attorney, I'm going to have to pay them this big retainer fee. In some instances, yes, but that is few and far between. That is different. We do a lot of things. You can find and afford an attorney that is willing to work with you in a way to make that advocacy available to you. Absolutely. Everyone can afford an attorney. You absolutely. The retainer fees were definitely the first thing. Retainers, I usually do explain retainers really quickly because I think we got about 10 minutes left. Retainers, I usually reserve using retainers with larger companies and larger clients, like advocacy available for people. So moving on with Jesse's question is that I'm wondering what, if anything, we can do during the interim to protect our work while also sharing online to reach potential clients, other than overly watermarking, perhaps password protecting our portfolios, and so on and so forth. Okay, so it used to be that I would say, you don't need to do any of that stuff. Before artificial intelligence, put it out there. Just put it out there. Because if you remember what I was talking about, copyright protection is automatic. As soon as you create something that is original, fixed in a tangible medium of expression, the US Constitution says you have copyright protection. You own the copyright in that work. You go register with the US Copyright Office, which that is the number one thing you all should be doing, is if you are creating something, add that cost to your budget. So this is the way that I put it to people. If you are a visual artist, and this can be taken for a novelist, that can be taken for filmmakers, anybody, it's going to cost you something to create your work, right? Add it to your budget. So if you're a creative, if you're a visual artist and you have to go buy your paints, your paintbrushes, your canvas, so on and so forth, on that list of things that you've got to acquire to create that piece of work, add in copyright registration to your budget. $65 for a standard copyright. Add that to your budget to go in and register your copyright. Add that to your budget. That is the number one thing. Number two is, like I was saying before, I used to tell people you didn't have to do all. You don't have to watermark. You don't have to do all that stuff. I highly encourage you to watermark. In some way, I highly encourage you to watermark. Because what we're now seeing is on the trademark infringement side of artificially intelligent generated creative works, is that these these intelligence platforms that are going out and scraping the internet are sweeping up images of trademarks. So when they're producing and generating these creative works, every once in a while, you're starting to see them generate something that has somebody's trademarked logo in that generated work. So now we're including trademark infringement within this world of artificial intelligence. So if you are watermarking, and you can go look up what's going on with Getty Images. Getty Images has banned anything. You cannot submit anything that was generated by artificial intelligence because they are seeing artificial intelligence generate works with the Getty watermark on it. We are seeing those trademarks come out. I would say watermark your stuff. Password protect your portfolios. Look into encryption. Look into those kinds of things. Those get really in the weeds and technical, but as we know, as arts and entertainment professionals, these are things that we're going to have to start learning moving forward in this industry to make sure that our work and our livelihoods are protected. So that's what I would say are some of the things that you can start doing now. The other thing is just pay attention to what is going on. Pay attention to, I know you guys have tons of things that you need to be worried about doing right now. When you're sitting around, take a look at the class action lawsuits, that the latest news on the class action lawsuits that are coming out, just to have a bit of a scope on what's happening, how things are progressing, where these lawsuits are going. It's still early, but things are going to start to change and they're going to start to swing. Lynn asked, those big companies got their legal teams working feverishly in the delays to come up with defenses. Absolutely. They're trying to come up with defenses, but the law is the law. And we as creatives have to do things like file lawsuits, class action lawsuits, and push this issue because we don't want to let this continue to get out of control. Because if artificial intelligence within creative works gets out of control before we can establish litigation, before we can establish legislation, before we can establish some laws and rules around it to control it, it could be devastating. Now, this is not me saying I don't like artificial intelligence. I like the idea of artificial intelligence and what it could do for people, inclusive creative professionals. This could really open the door for a lot of individuals who want to be in the creative space but did not have access. This could be a tool to bring access to people who don't have access to it. But we need to do it in an ethically responsible way to make sure that people's work that is being swept up in these trainings are asked for their permission. We've got to get past this idea that these companies can just go out and just sweep these things up and say, we didn't know, because they know what the law is. And B, making sure to give artists and entertainment professionals the choice. Right now, you have no choice. Everything's being scraped up and you're not being asked your permission. We need to put in at basic level some system to give artists a choice to say, yes, I would like to be a part of this training, or no, I do not want my work to be a part of this training. And if you say yes, then we need to start talking compensation. We need to start talking licensing. We need to start talking in the same direction that we talk in any other aspect of these industries. When we're talking about sampling of music, you have to pay licensing fees to do that. If we're talking about using somebody's visual art on a set design, in a movie or in a theatrical play, that artist is being paid a licensing fee to display their work in that film. If we're talking tattoo artists, who are, thank God, finally fighting back to get the same respect when it comes to seeing their art regenerated in video games, paid licensing fees. We need to look at this in that same light. Would blockchain be a possible strategy as well? Not that I understand it. Blockchain could have been a possibility to help out in this industry, but blockchain is really going through it right now. I have not been encouraging my clients to look into blockchain or NFTs or anything like that right now, just because the DOJ and the SEC are teaming up and really going after people in blockchain right now. So I would step back from blockchain right now until that world kind of fleshes itself out. Until that world kind of fleshes itself out, and right now I would steer clear of blockchain at the moment, but pay attention to it. Jesse says, do you have any recommendations for reliable sources to find the class action lawsuits? Are there any red flags we should be aware of when looking into these? If you're looking to be a part of a class action lawsuit, if you go on and Google any of the articles that are talking about the class action lawsuits, the good articles will have a link to the actual lawsuit that has been filed. If you look at the lawsuit, it will mention the attorneys and it will in the brief that was filed to the court, to the federal court, you'll see the names of the attorneys that are involved in it. There are law firms. You can look them up. You can call their law firms and check them out to see if they're still open, if you want to be a part of a lawsuit or anything like that, or see if you qualify to be a part of the class action lawsuit. I would just say call their law offices. That way you bypass any red flags. So, but if it's been filed in federal court, then you can feel safe that it's a legitimate class action. It may not have been registered as a class action yet, but it's been filed with the federal court. So you can go that route. All right. Are there any texts, books worth reading to understand more about AI? I do not have any book recommendations at the moment, but I would say there's tons of, as a matter of fact, I was on NPR the other day. There is a Harvard study going on right now around the ethical implications around AI. So I would go check out some of the texts and things that Harvard's got going on. They're talking about it. Here's the issue. Artificial intelligence has evolved so quickly. The resources are really not as vast as we need them to be right now. So that's why myself and others of my colleagues are doing things like this as much as possible so that we can engage and talk as much as we can and have these conversations, because the resources just aren't there right now. They're getting there. They're starting to come out, but we're trying to get more and more of those resources out there. What is the first thing artists should do if they think their work has been scraped and used for profit? Get in contact with a legal professional immediately. If you see something, first thing is save everything. Save everything you see, because that stuff can disappear. You might see it 1 second, try to go back and see it again, and it's gone. Save everything, screenshot everything, record everything, save as much information as you can, and then contact a legal professional. A lot of attorneys will document everything. A lot of attorneys will do free consultations just so you can present it to them, and then they can kind of give you some feedback to let you know if they think you've got something. If not, I know I do. I usually will talk to people for about an hour, just to get an idea of everything they've got going on. We may not be able to give you the whole answer because we still need to do a lot of digging and a lot of research to figure out the grand scope of everything. Because we could get into it thinking, hey, there's a lot here, there's something going on, and there might be one thing that kind of flips it and turns it. But we need to get into it just to check it out. Like I was saying earlier, every situation is different. So it just depends. But document everything and then reach out to a legal professional. That's exactly what I would say. Email links to your offices. All right. My law office, I'm the founder of my law firm, the Yates Law Firm, LLC. Again, I'm based out of New Orleans, Louisiana, but I work with artists and entertainment and arts professionals across the country. I'm redoing my website. So if you try to go to lawyerwynton.com, it will not pop up right now. I am redoing it because it was terrible. But you can email me at Wynton@lawyerwynton.com. And I have my phone on me constantly. And I have my laptop everywhere with me. Over the next couple of days, I may be slow to respond. I'm in Hawaii at the moment, but we'll be back in New Orleans within the next couple of days. So if I'm slow to respond, don't take it as if I'm ignoring you. I'm just wanted to get the kids out of just wanted to get the kids out for a couple of days. No, not fancy at all. This is my first time being here. I'm not fancy at all, trust me. But yes, that's my content. And if you want to follow me on TikTok or YouTube, it is Lawyer Wynton on both TikTok and YouTube. I love TikTok. I'm a huge TikToker. TikTok tie pin. Yes, somebody knows my lapel pins. Yes, I love lapel pins. So if you go to my TikTok, I love lapel pins. Whenever I do go to court, I have to wear a suit. Very rarely do I have to wear a suit, but when I do, I like to wear a fun lapel pin because I'm a massive nerd. I follow you on TikTok, and now I am following you on IG. Rashawn, I appreciate you guys. You guys are amazing. I'm trying to be more active on Instagram, so I promise I will do that. And then TikTok, I'm going to start trying to do more lives, kind of in this capacity where I get to talk to people. I'm going to start doing that more often and more consistently. So if you want to reach out on any of those platforms, just reach out to me. You can direct message me, shoot me an email, and I'll get back to you. We'll definitely be following you after this. I appreciate it, Jesse. But yeah, so it's Lawyer Wynton on all platforms. If you find me on Facebook, you will not hear from me. I'm never on Facebook. But Instagram, YouTube, TikTok, that's where I'm at. Or just email me, Wynton@lawyerwynton.com. Again, this was amazing. I really appreciate you guys hanging out with me here at VirtuousCon. VirtuousCon is an amazing resource. And I really hope that I can be a part of this again next year. Hopefully I can bring in some of my friends to talk more with you guys about all of the stuff the happenings going on in this world. But yes, thank you for you guys' time, attention, engagement with this conversation here at VirtuousCon. Artificial intelligence, creative works, and its intersection with the law. So I know the law can get kind of dry sometimes. I hope I kept it interesting. If not, just shoot me a DM and tell me, hey, that was so boring. Just let me know. Again, thank you guys. I really, really appreciate it. I think this is going to end in a minute. And thank you, VirtuousCon, for having me. I really appreciate VirtuousCon having me on this panel and to be able to present this information. This is my passion. And I just really adore VirtuousCon for even existing, especially for Black creatives. This is amazing. I love this. When I saw this about VirtuousCon and like Black creatives in sci-fi and comics and all that stuff, my heart just exploded because I have been a blurred all of my life. I can't wait to get back to New Orleans because my 3D printer has not been running, and I've got some Mandalorian helmets to build because season 3 is coming out, so I'm excited about that. But yes, thank you, VirtuousCon. Keep doing what you're doing for the Black nerd creative world. because we need it. We really need it. We need to keep having conversations like this. So if any of you guys ever need anything, just please reach out. I'm a nerd. I'm a creative first. I'm an attorney second. I always tell people, because that's how I got into being an attorney, is that I grew up as an actor, an entertainer, a young filmmaker, a photographer. I had a photography video production company with my best friends back in the day. We used to sneak into a lot of concerts and stuff. So I grew up doing it, and then I got older and said, I really want to help people protect themselves in their work. So again, really, really appreciate it. Yeah, I really appreciate it. You guys enjoy the rest of Virtuous Con. Again, thank you, Virtuous Con. If you guys need anything, reach out to me, Lawyer Wynton, on all platforms, and Wynton@lawyerwynton.com. You guys enjoy the rest of this amazing con. I'll see you guys soon.